For the last few days, I've been talking about the so-called assault weapon ban and the magazine bans in the state of Illinois that are making their way to the United States Supreme Court on an expedited basis and what that might mean for our rights. Well, today, a major event has taken place. Huge lawyers on behalf of the National Shooting Sports Foundation have just filed a major brief that's going to sound very similar to the sorts of things we've talked about here at the Four Boxes Diner about how one analyzes so-called arms ban cases under the Second Amendment. This is very good news for a lot of reasons for our right to bear arms. Stay tuned. We're going to break it down when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the best-selling new book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. A very important book where I try to teach Americans the importance of having firearms and knowing how to use them and to learn from the mistakes made by the Ukrainians and the Ukrainian government, including the fact that they refused to adopt a Second Amendment right to keep and bear arms 10 years ago, and lo and behold, did that come back with a heavy price a decade later. Check it out, Disarmed. Okay, folks, for the last several days, I've talked about different issues associated with the National Association for Gun Rights case, also known as Bevis versus the city of Naperville in the state of Illinois, involving the various so-called assault weapon bans, which are semi-automatic rifle bans, and magazine bans with magazines that hold more than 10 rounds. Now, we've talked about some of the procedural posture here, where you basically have two parallel cases, or two sets of cases that are going up on parallel path. One is the Bevis versus Naperville case, which got to the Seventh Circuit Court of Appeals first. That came out of Chicago. The district court judge there, Judge Kendall, did frankly a terrible job misanalyzing the Second Amendment. The Seventh Circuit basically did not disagree, at least at first blush, and the lawyers there took a powerful writ, or really a powerful application for an emergency injunction enjoining the Illinois state gun bans and magazine bans to the United States Supreme Court. After that occurred, Supreme Court Justice Amy Coney Barrett saw the brief by the plaintiff's lawyers supporting the Second Amendment and directed the defendants, i.e. the city of Naperville and the state of Illinois, to explain themselves, to explain how what they're doing is somehow consistent with the Second Amendment's right to keep and bear arms. That is one parallel set of cases. But there's another parallel set of cases, or another set of cases going on a parallel path. That is the set of cases that was in front of the Southern District of Illinois federal judge, Stephen McGlynn. After a major hearing and major briefs being submitted by the parties, Judge McGlynn entered a very powerful decision, concluding that indeed the Illinois ban on semi-automatic rifles and on magazines violated the Second Amendment and were enjoined. The state of Illinois immediately took an appeal to the Seventh Circuit Court of Appeals, which is the court that oversees the district courts in Illinois. And basically, after a day or two, Judge Frank Easterbrook, a notoriously bad judge when it comes to the Second Amendment, and everyone knows this, everyone in the Supreme Court world at least knows it, Judge Easterbrook basically stayed, which meant stopped the injunction entered by Stephen McGlynn. Now, in a prior video, I explained why Judge Easterbrook's decision to stay Judge McGlynn's injunction order was wrong, and why I'm not surprised that Judge Easterbrook did this. Now, that is the backstory. So something huge happened just now in front of the U.S. Supreme Court that I think is going to dramatically increase the odds of a favorable outcome in the short run involving these bans out of Illinois. That is that the National Shooting Sports Foundation filed an amicus brief in support of the plaintiffs, i.e. in support of the National Association of Gun Rights. Now, the National Shooting Sports Foundation is reputable enough, of course, but that's not what makes their brief important. What makes their brief important is that the law firm and the lawyers that submitted that brief, and at the United States Supreme Court, who the lawyers are, rightly or wrongly, is very important, because the Supreme Court wants to know that they can trust the quality of the lawyering. And if you have powerful Supreme Court advocates that are well known, that is a positive and increases the chance of a favorable outcome, and that your case will be more seriously considered. The lawyers representing the National Shooting Sports Foundation in that amicus brief to the United States Supreme Court are none other than Paul Clement and Erin Murphy. These are the lawyers. Specifically, Paul Clement is the lawyer that argued the Heller case and won it. Paul Clement is the lawyer that that argued part of the McDonald case in 2010 before the Supreme Court and won it. And Paul Clement is the lawyer that argued NSSF versus Bruin for the Second Amendment plaintiffs in NSSF versus Bruin and won that case as well. Paul Clement is a well-known Supreme Court litigator to everybody and everyone associated with the Supreme Court. He's a former Solicitor General of the United States, and everyone knows that his partner, Erin Murphy, a former Supreme Court clerk and another high-power, deeply intellectual lawyer as well. So the fact that Paul Clement and Erin Murphy have submitted this brief to the United States Supreme Court speaks volumes and will be taken extremely seriously by the United States Supreme Court. Now, that is the context. Now, the good news is, and remember, I told you, if you watch the Four Boxes Diner Second Amendment channel here, I will make you the smartest person in the room when it comes to the Second Amendment. I will give you information that is on par, if not exceeding, most lawyers and JDs and scholars and PhDs in America. I will make you smarter on this topic than most of them, if not all of them, when you're done watching my videos. And I just want to prove that point, that this is true. Because if you look at the brief submitted by attorneys Clement and Murphy, you will find that the arguments made in this brief to the United States Supreme Court in this hugely important case involving so-called assault weapon bans and magazine bans is essentially tracks many of the arguments, if not all of them, that we've made on this channel, we've talked about on this channel, just to show proof of concept of why you watch this channel and perhaps not other channels, because you want to know the detailed geeky stuff, and this is when it pays off. And I'm going to submit, or I'm going to put a link to this brief down below, and you can compare it. And if you've been following this channel and you read the brief, you're going to see a lot of similarities between the points that I've been making and now the points that the National Shooting Sports Foundation is making to the United States Supreme Court. Okay, now let's carry on. Again, if you're dealing with a gun ban case or an arms ban case, you know what I'm about to say. The applicable law is Heller. Heller dealt with a gun ban case. DC banned handguns. And when you're dealing with a handgun ban case or any arms ban case, the first and only critical question one has to answer is, once something is considered an arm, which is anything that can be used offensively or defensively. And in this particular case, obviously semi-automatic rifles are arms, and obviously magazines that go along with these are arms because they're necessary components and essential components to operate modern firearms, which are semi-automatic firearms. You need to have magazines, and of course, as you know, the Supreme Court in Bruin says that any object that facilitates, key word we've talked about before, the word facilitate. The Supreme Court said that any object or item that facilitates armed self-defense is an arm for the purposes of the Second Amendment, because bullets, for example, facilitate armed self-defense, because magazines facilitate armed self-defense, because scopes facilitate armed self-defense, because suppressors facilitate armed self-defense, and so on and so on. These are considered arms under the Second Amendment's right to keep and bear arms. So the first point that the attorneys for the National Shooting Sports Foundation make, Paul Clement and Erin Murphy, of course, is that magazines and the semi-automatic rifles that are being banned and restricted by the state of Illinois and the city of Naperville are indeed arms. I think that's a no-brainer decision. They do an excellent job laying this out in the brief. You can check it out in the link. But then they go on to talk about, now once these are deemed arms, guess what? It's the in common use test. Now, I want to digress briefly before we talk about the obvious evidence that shows that these weapons, these arms, are in common use. There's a few other critical points that Clement and Murphy made in their brief that I think is quite compelling. I thought they did an excellent job of politely and professionally laying out the fact that Judge Easterbrook, now they didn't name him by name. That's not how they do it. At the Supreme Court, remember, everything is the maximum level of civility when you're in front or involving the Supreme Court. Your adversaries before the Supreme Court are referred to as your friends, my friends on the other side. That is what is expected of you when you're actually litigating before the U.S. Supreme Court. So here you have what Clement and Murphy argue essentially is they make references to some judges in the Seventh Circuit Court of Appeal appear to continue to believe that certain cases that existed involving interest balancing tests, such as Friedman versus Highland Park. That's right, Friedman versus Highland Park was written by Judge Frank Easterbrook, and the brief here by the National Shooting Sports Foundation politely indicate that indeed some, which means technically speaking one or more, that's all some means, one or more, it could mean all, for those people getting ready to take the LSAT, but some means at least one. So when they say some judges on the Seventh Circuit Court of Appeals appear to still believe that Friedman versus Highland Park, which was clearly wiped out by Usurper versus Bruin and by Heller, frankly. This came after Heller, but it was clearly wiped out now by Bruin. Some of them still think that is good case law. That is basically Erin Murphy and Paul Clement's polite way of saying that Frank Easterbrook is still on his hobby horse of embracing this opinion he wrote that is clearly wrong, so wrong that Clarence Thomas and Justice Scalia blew it up in their dissent from certiorari in the Highland Park case. The next point that the National Shooting Sports Foundation amicus brief makes, which is something we've talked about on this channel before, is how easy these assault weapon cases should be. These are extremely easy cases. They should be eminently winnable, should not be hard at all. And we'll see what happens with the Supreme Court. But this is what they write, and this is the summary of the argument, and I could not agree more with this. They go on to say, quote, "There are many difficult constitutional questions surrounding the regulation of firearms. Whether Illinois or its municipalities may ban firearms and magazines owned by millions of law-abiding Americans for lawful purposes is not one of them." Period, close quote. They're making the exact argument here that says, you can have a lot of debates about lots of topics involving the Second Amendment, but the one clear-cut case is if a particular type of arm is in common use by Americans for lawful purposes, it's game over, period, full stop, we win. And when you're dealing with semi-automatic rifles and we're dealing with magazines that hold more than 10 rounds, there are literally tens of millions of these owned by Americans. There's no debate about that, that indeed these are obviously in common use for lawful purposes by Americans today. And again, the Clement Murphy brief does an excellent job of emphasizing that the in common use test is what's in common use today, right now. It doesn't matter what occurred in the past or which guns were invented when. The bottom line is these are in common use today, and therefore they're protected under the Second Amendment and cannot be banned. Period, full stop. Now, just to put this into some interesting context, I think they draw an interesting analogy. They point out that the firearms that Illinois has banned are more common than the most popular truck in the United States, and the feeding devices it has banned, which is the magazines, of course, that hold more than 10 rounds, are at least 10 times more common than that. They go on to compare the number of people, or the number of these firearms that exist in America versus the number of Ford pickup trucks, the 150 pickup truck, I believe, and they basically say that it's not even close. There's far more of these firearms than the pickup truck. And of course, we've talked about this before. The best evidence that no one talks about, unless you're a true Supreme Court geek or you're a Second Amendment geek, which I know you are on this channel, is you have to talk about, because it's such a great case for the Second Amendment advocates. That is the Staples versus United States case. And if you talk about a gun ban case and you don't talk about Staples, it tells me you don't know what you're talking about. We see a lot of anti-gun decisions and a lot of anti-gun briefs that conveniently ignore Staples versus the United States, which either tells me they're actively trying to hide that precedent, or they don't know what they're doing. It could be a combination of the two. But of course, Paul Clement and Erin Murphy know what they're doing, and they specifically put up front and center the Staples versus United States case from 1994, the U.S. Supreme Court case, and they say specifically, quote, "As recently as just a few decades ago, it was common ground that these common arms are lawful," citing the Staples versus United States, and then they go on to say, "and millions of law-abiding Americans continue to legally possess them." Again, they put Staples front and center in their brief, and I could not agree more, and that is a powerful Supreme Court precedent that often gets overlooked, pointing out the importance of semi-automatic rifles and how common they are, going all the way back to literally 1994, and there's a lot more AR-15 or AR style and AK style firearms, semi-automatic firearms today and rifles today than 1994. That is a fact. Moreover, the brief goes on to specifically use a word that I have frequently used here, which is that these arms, these semi-automatic rifles and these magazines are ubiquitous. They are ubiquitous, which means they are literally everywhere. For something else that's ubiquitous, think about like Coca-Cola is ubiquitous. I mean, it's like everywhere. This brief goes on and takes head on the fact that these certain words like weapons of war are propaganda terms invented by the anti-gun movement. Specifically, what they write is, quote, slapping the label assault weapon or moniker weapon of war on firearms owned by millions of Americans for lawful purposes such as self-defense does not take them outside of the scope of the protections of the Second Amendment. Very powerful language and could not be more true no matter what, because it's clearly a true statement. These propaganda terms are nothing more than that. They don't actually get to the essence of these firearms, which are just their ordinary semi-automatic firearms that require magazines to operate in a modern American life. Then this brief by the National Shooting Sports Foundation goes on to say that the court has made it clear over and over and over again that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. Now, this is essentially can be summarized by the Mark-Smith rule that you can take and use, and the Mark-Smith rule is this: when in doubt, take it out. When in doubt, throw it out. When in doubt, throw it out. And what that means is that if there's any doubt about whether or not a modern-day gun control law is constitutional under the Second Amendment, you toss it out. You throw it out. You get rid of it. Because no different than when I go into a court of law as a criminal defendant, the presumption of innocence is in my favor and the burden of proof is on the government, so too that once the plain language is triggered, meaning that we're dealing with, among other things, a regulation on firearms, the burden of proof to prove the case to show that a particular gun ban law or regulation is constitutional goes to the government. The government has the burden to prove that. And when you're dealing with a ban on modern firearms, the government has the burden of proof that those weapons are not in common use, which is simply impossible dealing with magazines and semi-automatic firearms because they are literally ubiquitous. There are tens of millions, if not hundreds of millions of these things in America, and they're everywhere. And of course, everyone understands this, so there's no way the government could ever show these are not in common use by Americans for lawful purposes, because it's simply. And then the brief goes on to specifically say that as Bruin squarely held, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Did you see what it said? All instruments that constitute bearable arms, which means arms that you can carry, even those that were not in existence at the time of the founding. That's what the Supreme Court said in Bruin and Heller. So again, we're not limited to muskets. We're not limited to, it doesn't matter when certain weapons are invented, although it's kind of interesting that the Girondoni air rifle that carried somewhere between 22 and 24 rounds that could be fired without reload, over 20 rounds, was carried by Lewis and Clark in the expedition sent out west. They were sent out west to investigate the Louisiana Territory after Thomas Jefferson, the president, acquired this land from Napoleon Bonaparte. Certainly that is interesting and tells us that none of this stuff is particularly new. But at the end of the day, the only question is, are these arms in common use by Americans for lawful purposes today? And they are, and therefore they're protected. It should be an open and shut case, and a very easy one at that. I think their argument on magazines was also quite good. It's something we've talked about on this channel repeatedly. A lot of this is going to sound very familiar to you. This is what they argue to the Supreme Court, to Justice Barrett, quote, feeding devices are not, and they're talking about magazines here, quote, feeding devices are not just holders of ammunition. They're an integral part of the mechanism that makes semi-automatic firearms work. When a user pulls the trigger, the round in the chamber fires and the semi-automatic action combines with the magazine to feed a new round into the firing chamber. Without a device to feed ammunition to the firing chamber, modern semi-automatic firearms cannot operate as designed and intended and are little more than over-engineered clubs. Bingo. Exactly right. Exactly right. They go on to point out the thing that we've talked about before, that, quote, without bullets, the right to bear arms would be meaningless, and the central purpose of the Second Amendment, self-defense, would be eviscerated. Absolutely 100% true. This brief also does a wonderful job using Caetano versus Massachusetts. I've always thought that was an important case. We've talked about that even before Bruin was decided, how this is going to be so important. And sure enough, they talk about Caetano versus Massachusetts, and they point out that in the current Samuel Alito talks about, quote, the pertinent Second Amendment inquiry is whether stun guns are commonly possessed by lawful Americans for lawful purposes today. And you see the key word? Here's the key word. Whether stun guns are commonly possessed. Say it with me, folks. Commonly possessed by law American citizens for lawful purposes today. Period, close quote. Sam Alito, Caetano versus Massachusetts. Why is this important? because the anti-gun movement is trying to say that the legal standard is that we have to show in the Second Amendment community in some way that these semi-automatic rifles are commonly used for self-defense by demonstrating that we have to pull the trigger all the time, every day, to show they're in common use. And that's not true. Not true, because the mere possession of a firearm is using it. The mere possession of a life insurance policy is using it. The mere possession of a fire extinguisher is using it. You see, a firearm, the mere possession of a firearm, including a semi-automatic firearm with magazines that hold more than 10 rounds, the mere possession of it is using it. When a police officer walks down the street with that firearm in his holster or holding it in Times Square when it comes to AR-15 style firearms, they are using it. Even if they never pull the trigger in their entire careers, they've used the gun their whole life, even though they never pulled a trigger in self-defense or any other purpose, they're still using it. And that is what Samuel Alito said in Caetano, and this brief makes a powerful point that that is true, because it certainly is. Now, I just want to sum up. What's interesting here is that the brief by Paul Clement and Erin Murphy actually make a reference to Judge Benitez's decision. They cite to Miller versus Bonta, the 2021 decision involving the so-called assault weapon ban, where Judge Benitez declared the ban in California to be unconstitutional. Now, I want to pat myself on the back because, as you all know, there's a very handsome YouTuber that was quoted extensively in Judge Benitez's decision, striking down or declaring unconstitutional the assault weapon ban in California. And yes, indeed, I'll put a link to it down below and through the article he cited in the Harvard Journal of Law and Public Policy of one Mark Smith of the Four Boxes Diner. You may have heard of him, I'm not sure. But nevertheless, I'm happy to see that Paul Clement and Erin Murphy are citing to Miller versus Bonta, which of course relied in part on Mark Smith. We like that. The last point I want to make is an important one that you should always remember. When you're debating guns, it's extremely important. I'm doing a lot of media work on this. I was talking about this with Lars Larson just last night. I was talking about this on the Charlie Kirk show just yesterday. I was trying to drive something critically home, which is that whenever there is a mass shooting, whenever there's a high-profile shooting, the anti-gunners want to immediately entice us into a debate about good and bad on guns. Now, of course, we win the debate on good and bad of guns. Nevertheless, never forget that the first point is that the Supreme Court itself says that the mere fact that some psychopathic nut jobs may misuse firearms is not relevant, is not a basis for restricting our right to keep and bear arms. Because when the Supreme Court says that tiers of scrutiny, which is a balancing test, or interest balancing tests of any sort are not relevant to the Second Amendment, what they are saying is you do not weigh the good and the bad of guns in the context of our right. That's right. The mere fact that someone might misuse firearms is not a basis to restrict the rights of the law and don't just trust me in the Four Boxes Diner here. Don't just trust the National Shooting Sports Foundation brief here. Trust the United States Supreme Court, because this brief makes the powerful point that in Heller specifically, the Heller dissenters, that's Justice Stevens and Justice Breyer, made a very big deal about how handguns are specifically linked to urban gun deaths and injuries and are overwhelmingly the favorite weapon of armed criminals. Now, the point is that the Heller majority, the Supreme Court, never disputed any of this, that people misuse firearms, but they found it to be, irrelevant, because our rights as Americans under the Second Amendment are not to be shrunk, are not to be taken away, are not to be reduced, because some nut job misuses a gun. That person should be punished. Yes, he or she should. But that is not a basis for taking away rights. That is what the Supreme Court says here. And on page 12 of their brief of Paul Clement and Erin Murphy, they make that very powerful point, specifically what they say, quote, "There is, of course, no question that these arms can be used to perpetrate horrific crimes, just as nearly any modern firearm can. But that has nothing to do with the relevant legal question presented here, i.e., whether these arms are typically possessed by law-abiding citizens for lawful purposes." And the question is 100% yes. So to summarize, the arguments that you've heard on this channel for the last many, many months, probably going back over a year at this point, you will find them beautifully summarized and articulated in a wonderful way far better than I probably articulated on this channel, and I'm going to put a link to this brief down below. To the extent that you're litigating or you're involved with any of these cases, you're definitely going to want to check out the way this argument was made by Paul Clement and Erin Murphy. This is not to take away any of the quality legal work that I've seen on behalf of the Second Amendment across the country, but I think that this is a nice synopsis, a beautifully written brief that other people can look and use as a template for dealing with arms ban cases. I think it should be a slam dunk win. Now, as to what's going to happen here, again, remember I told you that the Supreme Court generally doesn't like to get involved with cases that are on an interlocutory footing, which means they're in the middle of the case. There is not a final judgment. Usually the Supreme Court likes to act when there's a full-blown final judgment after the whole case has been completed and all the appeals have been exhausted and all the arguments have been put forth and set forth and so on, before the Supreme Court likes to get involved. And therefore, I think there's still a good chance the Supreme Court will not do anything involving the city of Naperville case, involving the National Association of Gun Rights, or any of these other things on an interlocutory basis. On the other hand, this is such a clear and straightforward case, and the fact that Paul Clement and Erin Murphy, who are prominent Second Amendment lawyers, some of the most, if not the most, some of the most out there in the country, very well respected by this Supreme Court and others. So I think it is a big deal they submitted this brief, and I think it dramatically increases the odds of some sort of success for the Second Amendment, but only time will tell. We will certainly know more in the next few weeks, and we will keep you apprised here at the Four Boxes Diner. So, okay, folks, hope you learned something here today at the Four Boxes Diner. If you haven't subscribed, please do so. Please also check out my book, Disarmed, and if you have bought the book or read the book, please consider posting a review on Amazon. A lot of people read those reviews on Amazon. That'll make a big difference to me in getting the book out to more and more people. And again, if you haven't subscribed, please do so here at the Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.